Hello, dear students. We are going to discuss today Sources of Muslim Law Part 2. In my previous lecture, we had talked about the first two primary sources of Muslim law, Quran and Sunnah. In this lecture, we are going to discuss the remaining portion of sources of Muslim law. In the end, I'll talk about schools of Muslim law also, though in brief only. So far we had discussed Quran and Sunnah as primary sources of Muslim law. The third primary source of Muslim law is known as ijma. In English, we call it unanimous decisions of jurists. The shortest possible definition of ijma can be given as agreements of Muslim jurists in any age on any juridical rule. This means that in any age regarding any legal rule, if there is agreement among Muslim jurists, then that agreement is known as ijma. This is a very important third source of Muslim law. Now, a question emerges as to what is the validity of ijma as a source of Muslim law. How can we say that ijma is the third primary source of Muslim law? The answer is that it is based on a verse of Quran and a very famous hadith tradition of Prophet Muhammad, peace be upon him. Quran in chapter 4, verse number 59 says, "O ye who believe, obey God and obey the Prophet, peace be upon him, and those of you who are in authority. And if ye have a dispute concerning any matter, refer it to God and the Prophet, peace be upon him." If you analyze, you will find that this verse says that obey God and obey Prophet, and those of you who are in authority. That means after God and Prophet, those who are in authority should be obeyed. Here, the word authority does not mean political authority. Here, authority means those people whose conducts are righteous conduct and they are learned people. They also need to be followed after God and Prophet. So this is very clear that if one does not find any solution regarding any problem in the first two sources, then that person should follow or take advice from those who are in authority. This very clearly creates the provision for ijma. Now, in the hadith, it's a very famous hadith that I have quoted in the slide. Prophet Muhammad said that there can be no consensus on error or misguided behavior amongst my people. This hadith, according to Muslims' opinion, says that if consensus has to be emerged, it is not possible on error or misguided behavior. For consensus, the action should not be erroneous. It should not be misguided behavior. This means that consensus is possible only when the behavior is a righteous behavior. Here also, there is importance of consensus. It means if there is consensus, then the result is very important. And that consensus forms ijma. What is the need of ijma? If you ask this question, then the explanation is that if Quran and traditions, that is Sunnah, cannot supply any rule of law for a new problem, the law-making person's jurists can find a solution by their unanimous agreement, by their common opinion. However, that unanimous agreement or common opinion must be in the light of Quran and Sunnah. Over a legal point, if such common opinion or unanimous agreement emerges, then that is called ijma. Now, who are the people who take part in ijma? The answer is they are known as mujtahids. In Arabic, the word mujtahid is used for jurists. This means that those persons who are jurists, they take part in ijma to evolve solution to any given problem in any particular age. Now, who can be a mujtahid? The qualification of mujtahid is that number one, that person must be Muslim, that person must be sane and adult, and he must be a person of righteous conduct. In addition to these qualifications, he must have sufficient knowledge. If all these qualifications are possessed by a person, that person can act as mujtahid. So, these jurists, in any age, when they face a problem, the solution of which does not exist in Quran explicitly or Sunnah, then with the help of consensus of opinion, they can solve the problem. This is how ijma is done, and ijma plays a role as a source of Muslim law. There are various kinds of ijma. The first kind of ijma is ijma of companions of Prophet, peace be upon him. The ijma of companions of Prophet, peace be upon him, are considered to be the most valuable, authoritative, and reliable. It is believed that the companions were the best persons to act as jurists. This is the most valuable and authoritative ijma. The second kind of ijma is the ijma of jurists of any particular age, any particular period. Now, after the period of companions of Prophet, in any age, if any problem of law emerged, the solution of which did not exist in the first two sources, then with the help of ijma, that means consensus of opinion of the jurists, that problem used to be solved. Now, ijma of jurists is also very important source of Muslim law. This is the second kind of ijma. There is one third kind of ijma known as ijma of the people. That means the opinion, consensus of opinion of the people. This type of ijma has little value because of two reasons. First, it is not possible to evolve concurrent opinion or even absolute majority among the people at large, that is, the community at large. And the second reason is that one cannot expect that everybody who forms the part of the general public will be a learned person. Because of these two reasons, the ijma of the people are of little value. However, ijma of this kind still plays a role, but with regard to religious practices such as observance of fast, zakat, prayer, etc. These are religious matters. In religious matters, ijma of people are still considered to be very important. Now, what is the importance of ijma? Regarding importance of ijma, Faizi observes that Quran and Sunnah look to the past. Consensus, that means ijma, and qiyas deal with the future of Islamic jurisprudence. This statement is very significant. It throws light on the importance of ijma and qiyas. It says that after Quran and Sunnah, when a person does not find solution to any legal problem, ijma and qiyas play very significant role. That is why in future, whenever Islamic jurisprudence needs solution to any legal problem, ijma, that is consensus, and qiyas play very significant role. Importance of ijma as a source of Muslim law is twofold. First, it explains the first two sources, that is Quran and Sunnah. Through ijma, explanation of Quran and Sunnah is possible. And the second one is that new principles of law, which are not found in the words of the Quran or Sunnah, can be formulated according to the changing needs of the society with the help of ijma. Therefore, ijma is a very significant source of Muslim law. Having said that, there are certain things which must not be forgotten. In this slide, requirements of valid ijma are given. There are 4 requirements of valid ijma. Number 1, ijma shall not come in conflict with Quran and Hadith. No ijma, rule number 1 is that no ijma can take place which is in conflict with Quran and Hadith. That means the third source, that is ijma, cannot be made against what has already been given in Quran and Sunnah. Number 2, second condition says that once a question is determined by ijma, it cannot be reopened by individual jurists. This is very important. This point is very important. It says that if ijma has emerged, if ijma has been done, the solution of the problem has been found, so many jurists have taken part in ijma, now the chapter is closed. Solution has been found. Now it is not right for any individual jurist who has taken part in ijma to reopen that question. That means he cannot say that individually, after the ijma has been done, that he does not agree with the solution found. Though he himself took part in ijma and he agreed on the consensus of opinion, he cannot challenge that ijma. The third condition says that one ijma can be reversed by a subsequent ijma. However, this means that if any ijma is found to be not suitable later on or problematic, then that ijma can be reversed by a subsequent ijma. So changing a previous ijma is possible by a subsequent ijma. But no individual jurist can reopen the ijma which he himself took part in. The last one says that when the jurists of an age have expressed only two views on a particular question, a third view is inadmissible. This means that suppose when the process of ijma was going on, various views emerged. Suppose in a given situation, there were two groups of people, two groups of jurists, and only two kinds of opinions emerged on a particular question of law, then it is not okay to allow a third opinion later on. This means that if only two opinions had emerged during the ijma, it is not correct to allow any other opinion. Why it is so? Because these conditions, if you analyze these conditions, you will find that these conditions are necessary to make law certain. I have told you while teaching Hindu law that uncertainty of law is a very bad thing. If a law is bad, it can be rectified. But if law is uncertain, then it is not good for the society. So in order to do away with uncertainty in law, these conditions have been laid down. Now the fourth primary source of Muslim law. This is known as qiyas. What is qiyas? Many people have tried to define it. Some definitions are a bit difficult, but I'll try to explain what does it signify. In English, qiyas is known as analogical deduction or analogy. Abdul Rahim, a famous writer of Muhammadan jurisprudence, he says that an extension of the law from the original text. Qiyas is an extension of the law from the original text. That means there is some original text. That original text is extended to which the process is applied to a particular case by means of a common illat or effective cause. The original text to which the process is applied to a particular case. This particular case is a new case. This means that suppose for a problem, a solution existed in the first three sources: Quran, Sunnah or Ijma. Either in Quran or in Sunnah or in Ijma. Solution existed regarding any problem. A new problem, however, emerged, the solution of which cannot be found in the first three sources. This new problem, however, has some similarity with some old problem, the solution of which exists in the first three sources. Then the original text can be extended to this new problem with the help of common illat or effective cause. I'll illustrate it in a few minutes. How does it work with an example? Now, let us see, there is another way of defining it. The second paragraph says that qiyas or analogy is a process of deduction by which the law of a text is applied to cases which, though not covered by the language, are governed by the reason of the text. Chaos is a process of analogy. Analogy means when you have a similar problem, the solution of which existed, then that solution, if possible, may be extended to a new problem, the solution of which is required. And in this way, quite possible that we will find the solution of the new problem. Wilson is a famous writer of Muslim law. He says that it is an illogical deduction from the reason of a text to a case though not covered by its language. This is a simple definition of qiyas. However, it has the same elements which we find in other definitions. For example, the definition given by Abdul Rahim. Now, you can understand with the example I have given. Now, suppose this example says that strong drinks are prohibited according to Muslim law. Strong drinks, for example, alcohol, is prohibited according to Muslim law. The reason of the prohibition is intoxication. Intoxication. It intoxicates. The person becomes intoxicated when he consumes strong drinks. This is why strong drinks are prohibited in Muslim law. Now, with the help of this provision, the solution regarding wine and similar things can be drawn with the help of qiyas. If strong drinks are prohibited because of intoxication, wine is also prohibited because it has intoxicating effect. Similarly, in today's time, we have many such things like narcotic and psychotropic substances, which we commonly known as drugs. They also cause intoxication. We can extend the old provision to drugs also, because they also cause intoxication, and therefore, similarly, drugs are also prohibited. Since strong drinks are prohibited because of intoxication, wine is prohibited because it intoxicates. Similarly, drugs are prohibited because they also intoxicate. This way, solutions with the help of qiyas are found in Muslim law. So, we have discussed first, so far, the primary sources of Muslim law, which are Quran, Sunnah, Ijma, and Qiyas. Now, the secondary source. The secondary sources of Muslim law are customs and usages, precedent, legislations. What is the role of customs in Muslim law? Before the advent of Islam in Arabia, customs were the basis of entire social life, religion, morality, trade, and commerce. Customs played a very significant role in the society of Arabia before the advent of Islam. And no codified law existed. Therefore, they regulated their affairs with the help of customs only, whether it was a matter of social life, religion, morality, trade, and commerce. Custom played a very significant role. However, after the advent of Islam, customs lost their significance, and Quran and Sunnah replaced customs. In Islam, after the advent of Islam, customs role diminished gradually. Customs are not that significant as we find in Hindu law. As a matter of fact, Islam came against the existing customs. Nevertheless, customs influenced the growth and formation of Sharia in several ways. For example, a part of Sharia is based upon tacit and silent approval of Prophet. That means a part of Sharia comprises of those customs which Prophet himself tacitly or silently approved. So those customs which were tacitly and silently approved by Prophet, peace be upon him, they became the part of Sharia. According to Imam Malik, a famous jurist of Islamic law, his opinion is that customary conduct of the citizens of Medina is sufficient ijma in the absence of other texts. So according to Imam Malik, a famous jurist in Muslim law, the customary conduct of the citizens of Medina was a sufficient ijma if there was no other source, no other express text which was otherwise. Therefore, custom did play some role in the formation or development of Sharia. But custom is not that significant according to Muslim law as we witness in Hindu law. As far as condition in India is concerned, when in 1937 Muslim Personal Law Shariat Application Act was passed, it abolished most of the customary laws which were prevalent at that time in some of the Muslim communities. And for the entire Muslim community, that act made the provision that the customary laws will not apply in most of the cases, and in place of customary laws, the Muslim law shall apply. However, this act also did not completely abolish customs in Muslim law. It left some of the issues to be governed by customs even after the enactment of this act. For example, agricultural property, for example, legacy. In these matters, the customs were still important. Now, precedent. We all know that precedent is a very significant source of law. The laws and principles laid down by higher courts are binding on lower courts. This principle is applicable in every law, and Muslim law is no exception to it. We all know, whichever law we study, we know that precedent plays a very significant role. And Article 141 of the Constitution of India clearly states that the law declared by the Supreme Court of India shall be binding on all courts within the territory of India. Therefore, the laws and principles which have been laid down by higher courts are binding on lower courts. And in this way, though it is not the job of the court to create law, however, while delivering judgments, courts do propound new principles, and these principles become a significant source of law. Muslim law is also not exception to it, and therefore there have been several judgments in which the courts have propounded new principles, and those principles have become the part of Muslim law. We will gradually study as we will go ahead with studying different provisions of Muslim law in relation to marriage, guardianship, maintenance, etc. We will come to know how these decisions have shaped Muslim law. As far as the last source legislations are concerned, we witness that even in Muslim law, though Muslim law is largely uncodified in India, there have been many significant legislations. Only few examples have been mentioned here. I've given few examples in this slide. These enactments are either directly related with Muslim law, or at least one of them, the Child Marriage Restraint Act 1929, it has influenced Muslim law also, together with other laws. So legislation, which is a very significant source of law in the modern democratic welfare society, it plays a significant role so far as Muslim law is concerned. It plays a very significant role in Muslim law also. Therefore, legislation has affected Muslim law, and it has played its role in shaping what is known as Muslim law. Now, coming to one very significant point, that is, what are the primary sources under Shia law? So far, whatever we discussed the opinion with regard to Sunni law. Now, according to Shia law, primary sources are slightly different. The first primary source according to Shia law is Quran. The second primary source is again Hadith, which is known as tradition in English. But not all the Hadiths are recognized by Shia community. They recognize only those traditions and Hadiths which come from Prophet's family, the narrator of which is from Prophet's family. Only those Hadiths are accepted by Shia community. Ijma is again the third source according to Shia law, but Ijma to become a source of Shia law, it must be confirmed by Shia Imams. The fourth source is different as compared to Sunni law. In Sunni law, the fourth source was Qiyas. According to Shia law, it is reason. That is, in Arabic or Urdu, it is called Aql. Aql is the fourth source after Ijma. So, Shia law is slightly different as far as the sources are concerned. Now, coming to the last point and very significant point, schools of Muslim law. Schools of Muslim law have not been prescribed in your course, but you must have some information regarding schools of Muslim law also. Only then you will be able to comprehend this subject. According to Sunni law, but before that, let me tell you, as you all know, that the Muslim community the world over is divided into two groups. The larger group, according to population, is known as Sunni Muslims, and the population-wise, the smaller group is known as Shia Muslims. In India, we have both Shia Muslims and Sunni Muslims. According to Sunni Muslim law, there are four schools: Hanafi school, Maliki school, Shafi'i school, Hanbali school. According to Shia law, there are three schools: Isna Ashriya, the followers of 12 Imams, that is why they are known as Twelvers; Ismailiyas, they are the followers of 7 Imams, that is why they are known as Seveners; Zaydiyas, they are the followers of 4 Imams. Now, let us try to understand one by one. Hanafi school is followed by majority of the Muslim community, especially in India. The Sunnis, majority of the Sunnis in India follow Hanafi school. Although we have Maliki and Shafi'i Muslims also in India, but population-wise, they are in minority. Most of the Sunni Muslims living in India are Hanafis. Therefore, whenever I'll say Sunni law while teaching other topics. If I say Sunni law, I'll mean Hanafi law. Unless I have said, unless I say otherwise, then you should consider it. Whenever I'll say Sunni law, that will mean Hanafi law. This point you must not forget. And whenever I'll say Shia law, it will mean I'm talking about Isna Ashariya Shia law, 12 verse. Because these two communities are found in India in majority as far as the Muslim community is concerned. So whenever I'll say Hanafi law, it will mean Sunni law. Whenever I'll say Sunni law, it will mean Hanafi law. Whenever I'll say Shia law, it will mean Isna Ashariya Shia law. And whenever I'll say Isna Ashariya law, that will mean Shia law in India. So I hope that when we will start the next topic, for example, marriage, then marriage, dower, divorce, there are so many topics that we will discuss. Whenever I'll say Sunni law, you will understand that you will consider that I'm talking about Hanafi law. And whenever I'll say Shia law, you must keep in mind that I'm talking about Isna Ashriya law. So for today, this much I had to say. And in the next video, hopefully, we will talk about law relating to marriage under Muslim law. Thank you. Thank you very much.